Lawyers in Ekpe, Lagos have told the state government it's better to invest in projects for the benefit of residents than dwell on campaign promises. On TV News, learned that the lecture series of MBA Ekpe Law Week in honor of Honorable Justice Adeshola Oguntade focused on real issues of governance. The latest review of Lagos Land Use Act, we understand, was revealed for Lagosians to know why they have to pay more this time. Adering Olanrewaju is the registrar, Land Use Act Charge Asset Appeal Tribunal.
What the Lagos State government has done with the amendments is to create a platform of uniformity for all property owners. What it means is that each property owner will be able to know how much exactly his property is worth, and he can calculate what charges is expected to pay in terms of land use. There's also another provision in the new law for self-billing, which means that once you get the valuation of your property, you can file your documents, you can check how much exactly you are supposed to pay, you can calculate how much your land use charge is without the necessity of coming to the state government. And once you've done that, you can make payments. Presently for this year, the state government has said that you should pay 50% of the land use charge that is given to you. And if the property has been classified as commercial, if the property is classified as owner occupied, that is the owner is the one that is living there, you will pay 75%. That means you have a 15% discount. However, if the property is occupied by both the owner and the third party, then there's a 25% discount. That means you pay 25% of it. Now there's another early discounts. Other discounts will be applicable once the law is properly amended and passed.
Barrister Oladoton Hassan is the Assistant General Secretary for MBA Ekpe branch.
It's quite delightful to be part and parcel of this successful program of today of the Nigerian Bar Association Ekpe branch second our first lecture series in honor of Justice Oguntade. And this series has been one of the most remarkable one because it really brought to limelight the real issues as in relation to governance and the people. And as far as the program have been able to achieve, one cannot overemphasize the impact, especially on the roles of traditional institutions in administration of justice system, and also bringing the social justice right of the people from the perspective of the government themselves. There is need for proper explanation, there is need for proper orientation on government policies, on how those policies and the impact of those policies in the system. So therefore, today's occasion have been able to do justice to that interest. When one consider the state of the nation today, there is no way we need to really begin to think within. As Nigerians, there is a need for us to begin to have a collective mindset of administering ourselves. And the whole essence of this is in relation to the state of the nation, in relation to how we need to begin to see for alternative measure of resolving our crisis. There's a need for us to really imbibe our virtuousness spirit in ensuring that justice is manifestly seen to be done. And that's one key factor that the Lagos State government and under the Ministry of Justice and every of these agencies have been much more impactful to seeing rules on how issues like the land use charge will be resolved. You see issues of the Lagos Multi-Door Courthouse was also brought to the fore. Several other issues, if continuous mechanisms like this is being promoted, is being given the widest publicity, because this is it shouldn't be an annual thing. It should be a regular discussion, and that's one key advice that we want to give, that the Lagos State government should take a very subtle advantage of what the MBA Ekpe branch is doing, either via running a partnership with the branch or via also ensuring that via the branch they can also annex other branch of the MBA, so that simultaneously orientation programs like this can be a continuous process. So I think we have a very, very great, successful outing.
They also dwelled on traditional justice system for resolving conflicts.
Our traditional justice system is concerned, this has been the foundation laying of our administrative justice system as far as Africa is concerned. We cannot overemphasize the impact of African traditional measure of resolving crisis. And as far as we are concerned, especially within this part of the world, Yoruba land, every key obas, the violence, have special role in resolving disputes, in also providing solution.
Before time, there's been an existing role and an existing traditional system, albeit it had been the law has tried to codify it and formalize it in the customary courts. However, today we are looking at the role of arbitration, which is an alternative to resolving disputes. The role of arbitration and delivery of justice system in the traditional setting, traditional customary setting at the grassroots. Should the courts be filled with every type of litigation when it can be resolved via a system laid down by our customs and our tradition? Today, we are looking at how we can co-opt our custom and our system in the increasingly evolving arbitration system and the judicial system and the delivery of justice in the judicial system. So the purpose of this public lecture, which is part of our events of program at the Law Week 2018, is to co-opt the traditional rulers, train them, inform them of the modus and their relevance in the delivery of justice vis-a-vis arbitration or traditional arbitration in view. And the unique thing about this is that it is not a new innovation. It has been existing. We just want to give it a formal recognition, and probably we'll see what the law can make of this innovation.
Chairman of NBA Ekpe branch.
Dispense justice so that everything does not end in the court. In view of the new regime or new revolution of judicial system, which tends towards mediation. So even the mediation processes that we have now, if you are talking of the multi-door court house, it's still a court, the word court is there. And either two, people go to file their cases in court. So you see a multi-door court house. Now we are saying, how would the baales, the chiefs, and the obas be able to mediate between people and reach a final settlement? And where those settlements are done, where would they register it? Because part of what is happening is that we are talking of it's between oral and written processes. Most of the things that happen in the palace are oral and no document. So if there is a settlement on a particular issue today, after 10 years, if the man dies, the children can come up the same way and say we are not aware of it. So we are saying when there is a mediation in the palace, then there should be a register somewhere where they can register those settlements. So that's what we're talking about, and trying to bring out people and train them on how they can mediate on dispute, as against going to the conventional courts. That's what we are all doing here. And then we try to showcase the issue of land use charge. People are asking questions on land use charge. It's exorbitant. We have brought the government officials to come here to talk about it. We talk about the taxes. Is it necessary to pay tax? What are the pains and what are the gains for paying tax? And on the chieftaincy too, several disputes are not just land. They have to do with chieftaincy around us here. So we have more cases on chieftaincy dispute and land dispute around here. And that's why we have brought all these government officials to be able to talk to us from the chieftaincy affairs in the Ministry of Local Government and Community Development, from the land use charge, and then from the several other stakeholders to come and talk about it.
Well, the theme is striking the balance between justice and social infrastructural development. And we have topics. First of all, taxation, pains and gains. It is important for us to use this opportunity of us holding the second annual Law Week in honor of Honorable Justice Adeshola Oguntade to let the people of Ekpe know that it is important for us to consider the need for us to pay tax. While we do not denigrate the issue of tax, we now brought resource persons from the ministry, from Lagos State government, who are directly in charge of taxation affairs. Like somebody came from the Ministry of Land Use Charge, and she spoke to us extensively on how government arrives at the charges. And I believe from our explanation we've been well taught. And as lawyers, we could also explain to our clients, because some of our clients approach us with complaints, and at times you don't know exactly how to approach it. But with this public lecture, I believe to a very large extent, proper light has been shed on the issue of taxation. Then secondly, the role of traditional rulers as regards mediation is very important at this time for us to begin to consider reforms, law reforms, in the direction of incorporating traditional rulers, or the effort of traditional rulers, Bales, the chiefs and the Obas, second class, first class Obas. Some of the things they did in the past was to settle disputes for communities, and I believe that we should revisit that aspect, fine-tune it, and incorporate it with the spirit of mediation that the government of Lagos State has also been promoting through the Ministry of Mediation, the multi-door courthouse. So these are things that we believe that we have achieved. There are a lot of ballets here, there are a lot of chiefs here. We have over 150 of them in attendance today. And I believe that they will also go with the message to their people, and the job of the government will be easier. The hallmark of all of this is to show the people that the idea and the purpose of governance is to elevate the greater gain of the people. Even if you are going to pay tax, it's better for you to pay tax when you are sure that your road will be done. You understand? When you are sure that the drainage in your street will be done. At the end of the day, you have something better and greater to gain, and you have lesser to lose.
Traditional medium of justice administration has been around for a long time, ever before the time of colonization, and the traditional rulers were on ground, and they have been administering justice for a long time before the formal system of justice administration came on board. And of course, they continue to play a major role in terms of dispute resolution in their various communities on land matters, chieftaincy matters, matters relating to family succession, marriage, custody of children, and of course minor disputes that have been there all along before the colonial masters came and introduced the formal court system. But at the same time, though we have the formal court system now, it is still, the traditional system is still relevant, in that most of the community we have are rural or semi-rural, and most of the people there don't have access to justice system in the formal way, and they still resort to the traditional system, which of course have been playing a complementary role to the former system. It is where they are unable to agree we are at the statutory system level that they are put in former courts. And I think it is good, just as the NBA has done today, to encourage them to continue their role so that most of the cases that ought not to come to the former courts will not come to the former court. They will be resolved at the statutory level, and there will be peace and harmony in the community. You know, when you go to court normally and come back, you are hardly friends. But when you get your dispute settled in the palace of the Oba or chief or the Bale, people go back home happy and they still remain a family and friends. So they are still playing a very major role, which should be commended.
What you are saying is that if somebody goes to the Oba and he feels that there is a problem, that they can, like an appeal sort of system, go to the Montidor. You see, the problem there is that in mediation, because it is a participatory process, it's a party-driven process, the parties themselves are involved in the resolution of the dispute themselves. It will be difficult for them to renege, or we don't see people going on appeal. It's when judgment is handed over to you, you win or you lose. It's people that lose case that go and appeal. But in mediation, both of them is a win-win. Both of them sit down and agree. So the reason why the Oba will not have a preference, if they use mediation, properly so called, they can't have a preference, because mediation is fast, just facilitating communication between the two parties. They are the ones that are going to take decision themselves. So I cannot sit down and say, this is what I like. They want this, oh no, let's do it this way, let's do it this way, and we agree. And then I'm going on appeal. Do you understand? Or somebody is preferring. So that's why you will not see mediators collecting money, because it's not useful. At the end of the day, it is the parties themselves that take the decision. Okay. The objective of the multi-door courthouse and the traditional justice system is to help people to resolve disputes outside the court, the traditional court system. So anything that is aside, that is different from the traditional justice system, is an alternative dispute resolution system. Now, what the multi-door courthouse offers is alternative dispute resolution techniques, mediation, arbitration, early neutral evaluation, and all that. And we actually help people to resolve their disputes, either through court referral, that is the High Court or the Magistrate Court refers matter to the multi-door, or people walk into the multi-door with their disputes, and we help them to resolve. Now, what was an eye-opener to me was when I was a consultant to the British Council on traditional justice system, the role of traditional rulers in dispute resolution in Lagos State. I found out that a lot of citizens of Lagos State actually used the traditional justice system. They actually went to their Obas, to their Bales, to their Yellow Days to resolve their disputes. And they were talking of thousands of disputes that were resolved in a year within the traditional justice system. And they even used pilots cases of just maybe two of the areas in Lagos State. So, in which ways can we synergize? First and most importantly is training. The traditional rulers should have proper training in mediation. What they are doing right now is more of, maybe, should I say, customary arbitration, which is actually recognized. But it would be nice to empower people to be able to resolve their dispute themselves. And that is what mediation does.
Thank God for this year Law Week. We never expected it to be as interesting as it has turned out to be. Despite the shortest period for the planning, we are able to record a huge success. Kudos go to our chairman, Prince A.S. Abiola, for the quality leadership role and for leading us aright. We commend the immense contribution of the Excellency Governor Ambode of Lagos State for his support, the able Attorney General of Lagos State, and all other persons, including the Chief Justice of Lagos State, for the contribution to the success of this program. The topic of this year's program is access to justice. We are able to bring in and we are able to teach our traditional rulers their roles, their contribution, and how they can go by it in assisting in the dispensation of justice in Lagos State. We are sure and we are praying to Almighty God that by this time of next year, we will record more and more success than this.
On TV News, learned that MBA Ekpe Law Week seeks to raise issues of governance, call government to action, and promote democracy in the interest of the people.